Hello, and welcome to the New Jersey Department of Labor and Workforce Development's webinar, Compliance with New Jersey's Wage and Benefit Laws, What Business Owners Need to Know. My name is Nicole Jacoby, and I am the Community Outreach and Resource Planning Specialist for the Wage and Hour Division here at the New Jersey Department of Labor. And today I'll be taking you through this presentation about various important topics that business owners need to know in order to comply with New Jersey's wage and hour laws. Before we begin, we'll go through a quick disclaimer. This presentation is intended as general information only, and it does not carry the force of legal opinion. Please note that the law and regulations can change quickly. The New Jersey statutes and the New Jersey Administrative Code should be consulted for the most accurate and up-to-date legal information. The New Jersey Department of Labor helps all workers. We enforce laws to protect all workers, regardless of their legal status. We will never ask for immigration information, and we do not share information with immigration unless legally required to do so. An employer cannot withhold payment because an employee does not have a valid Social Security number or because an employee has not completed a W-4 or an I-9 form. Employers must not retaliate against their workers for exercising their rights or inquiring about their work rights. The New Jersey Department of Labor Wage and Hour Division. In this presentation today, we will discuss the following requirements for employers, which include earned sick leave, minimum wage, record keeping, methods of wage payment, overtime, child labor, misclassification, workers' compensation, and anti-retaliation. The first law we'll talk about today is earned sick leave. Employers of all sizes must provide employees with up to 40 hours of paid earned sick leave per year, so they can care for themselves or a loved one or for other reasons prescribed by law. If you have an existing sick leave policy, it must meet or exceed the requirements of the law. Employees accrue 1 hour of earned sick leave for every 30 hours worked, up to a maximum of 40 hours of leave per benefit year. For example, if an employee works 40 hours per week, then they will earn 5.33 hours of earned sick leave in 4 weeks. Employers can also choose to provide their employees with 40 hours of earned sick leave up front. And if an employer already has an existing sick leave policy for its employees, then it must meet or exceed the requirements of this law. Who is covered by earned sick leave? Earned sick leave applies to nearly all employees, including full-time, part-time, and temporary employees. It applies regardless of the number of employees that a business has or whether an employee is paid by cash, piece rate, or salary. It's also regardless of an employee's citizenship status, and per diem and seasonal employees are covered as well as supervisors and managers. Another important part of establishing an earned sick leave policy is establishing a benefit year. Benefit year means the period of 12 consecutive months established by an employer in which an employee accrues and uses earned sick leave. Employers must notify each employee of the benefit year in writing. And to change the benefit year, you must provide notice in writing to the New Jersey Department of Labor Commissioner at least 30 calendar days prior to the proposed change. When can an employee use earned sick time? They could use it to care for themselves or family members, for physical and mental health or injuries or wellness care, to get the COVID-19 vaccine or recover from side effects, to cope with domestic or sexual violence, to attend school-related meetings, functions, or other events for a child, public health emergencies that close work or the school or place of care of the child. And the fifth bullet point here about school-related meetings, functions, or other events for a child is very broad. So this could cover many different types of events that are taking place at school where the attendance of a parent or legal guardian is requested by a staff member at that school. Earned sick leave. What is the definition of family? Family can include a child, whether it's biological, adopted, or foster child, stepchild, legal ward, child of a domestic partner or civil union partner. Could be a grandchild, sibling, spouse, domestic partner or civil union partner, parent or grandparent, spouse, domestic partner or civil union partner of an employee's parent or grandparent, sibling of an employee's spouse, domestic partner, or civil union partner, any individual that's related by blood to the employee, and any individual whose close association is the equivalent of family. So the definition of family is very broad under the earned sick leave law in New Jersey. Using earned sick leave. An employer may choose the increments in which its employees use earned sick leave, provided that the largest amount of earned sick leave that an employee may be required to use for each shift is the number of hours that the employee was scheduled to work during that shift. Earned sick leave requirements. Employers must keep and maintain records for 5 years documenting compliance with earned sick leave, including hours worked, earned sick leave accrued, advanced, used, paid out, and carried over, and these records must be made available to NJDOL if requested. Employers must also give each employee written notice of their right to earn sick leave, and this notice should include how employees will accrue and use sick leave, and the right to file a complaint and be free from retaliation. A special note here is that the earned sick leave law states that records documenting compliance with earned sick leave must be kept for 5 years. However, other laws related to wage payment and record keeping may overlap with this. For example, there are other wage and hour laws that require employers to make these records available to wage and hour investigators during an audit for the prior 6 years. So it's just important to note that the earned sick leave requirement is specific to earned sick leave records, and that's for 5 years, but this may overlap with other wage and hour laws that require employers to keep records for 6 years. And there are a few exemptions from earned sick leave. This would include individuals that are employed in the construction industry under a union contract, per diem healthcare employees, public employees who are provided with sick leave at full pay under any other New Jersey law or rule, and independent contractors who do not meet the definition of an employee under New Jersey law. And we'll talk about independent contractors in a few more slides when we discuss misclassification. Few more earned sick leave requirements. If an employee has a need for earned sick leave, an employer may require documentation only when the employee has used 3 or more consecutive days, it is a high volume period for the business, or there is a special event. Employers cannot require documentation for just 1 or 2 days of absence. Employee health information and data in the employer's possession must be held confidential. An employer cannot discipline an employee who uses earned sick leave for a permitted reason. An employer is not allowed to require an employee to find coverage when using earned sick leave or make up the hours. An employer may require 7 days advance notice when an employee has planned to use sick leave. This could be an example of a doctor's appointment for wellness care. If an employee's need for earned sick leave cannot be planned, an employer may require the employee to give notice as soon as it is practical, and this would be an example of waking up with a fever unexpectedly. Employers cannot retaliate against employees for requesting or using earned sick leave, and you can learn more at our website, mysickdays.nj.gov. How are employees paid for sick days? Employees must be paid at the same rate they normally earn, not including overtime, and at least the minimum wage. Different calculations exist for the following types of employees: tipped workers, multiple rates of pay, piecework, commission. Employers are required to pay employees in the same or in the next pay period, and the pay must come with a regular paycheck or another method that can be deposited or cashed easily. To calculate the rate of earned sick leave pay for an employee whose pay fluctuates, has 2 or more different jobs, is paid by piecework, or whose pay includes gratuities, food, or lodging, you would add together the total earnings, exclusive of the overtime pay, for the 7 most recent workdays, and then divide that by the total hours of work during that 7-day period. And then for employees with base plus commission or commission only, the earned sick leave pay rate is the hourly base wage or the state minimum wage, whichever is greater. Unused earned sick leave. Unused leave time at the end of the benefit year is either carried over or bought back by the employer. Up to 40 hours can be carried over per benefit year. Employees are permitted to have more than 40 hours of earned sick leave in their leave bank. However, an employer is permitted to limit them to 40 hours of usage or carryover per year. And this is an example of the required earned sick leave poster that all employers are required to post at their worksite where employees are able to view it. And you can download and print out free copies of this poster and all of the other required posters in the employer poster packet on the New Jersey Department of Labor's website, which is listed here. And we also have posters in several other languages as well. New Jersey's minimum wage. Employers must pay New Jersey's minimum wage or any higher rate of pay agreed upon at the time of hiring. Effective on January 1st, 2024, New Jersey's minimum wage for most employers is $15.13 per hour. And the minimum wage may continue to increase each January based on a measure of inflation. The increase would happen on January 1st each year based on inflation. And you can see that there's a few different categories of employers for the minimum wage. For most employers, it's $15.13. However, for seasonal and small employers, special note, small employers are defined as employers with fewer than 6 employees. That minimum wage is $13.73 per hour. For agricultural employers, the minimum wage is $12.81 per hour. The cash wage for tipped workers is $5.26 per hour, and the wage for long-term care facility direct care staff is $18.13 per hour. And it's a great idea to print out this minimum wage chart and hang it up at your place of business so that you're always aware of what the minimum wage is and how it applies to your business. It's a great resource just to stay updated and make sure that you're paying the correct rate to your employees. And in the next few slides, we're going to go through a couple of these categories in more detail. The minimum wage for small employers. And to be defined as a small employer under New Jersey's wage and hour laws, you must meet both of the following 2 requirements. The first requirement is that in the current calendar year, you had fewer than 6 employees for every working day during the majority of the work weeks. The second requirement is, during the previous calendar year, you had fewer than 6 employees for every working day during at least 48 calendar work weeks. And if you're an employer that is newly established during the current calendar year, you could be considered a small employer if you employ less than 6 employees for every working day during a majority of the calendar work weeks in the current calendar year. Effective on January 1st, 2024, the state minimum hourly wage for small employers is $13.73 per hour. The key thing to note in this definition is that small employer is based on the amount of employees at your business. If you have 5 or fewer employees, you could be considered a small employer based on this definition. However, if you have 6 or more employees, you would not be considered a small employer based on the way it is defined in the law. Minimum wage for a seasonal employer. To be defined as a seasonal employer under New Jersey's wage and hour laws, you can meet any of the following 3 requirements. The first option is that your business provided services only in a 10-week period during June, July, August, and September. Or option number 2 is that during the previous calendar year, at least 2/3 of gross receipts were received in a continuous 16-week period. Or the third option is that in the previous calendar year, at least 75% of wages paid were for work performed during a single calendar quarter. And this doesn't include labor on a farm. The 2024 minimum wage for seasonal employers is $13.73 per hour. The minimum wage for tipped workers. The combination of wages and tips must equal at least the minimum wage per hour. If the tips plus the hourly wage are less than the minimum wage per hour, then the employer must make up the difference. Effective January 1st, 2024, the cash wage for tipped workers is $5.26 per hour, with employers able to claim a $9.87 tip credit. If an employer fails to pay the minimum cash wage to their tipped worker, which is $5.26 per hour, they cannot use a tip credit for that worker and would need to pay them the full minimum wage, which is $15.13 per hour. A tipped employee is any worker, full-time, part-time, or temporary, engaged in an occupation in which they customarily and regularly receive more than $30 per month in tips. Under New Jersey's wage and hour law, an employer is eligible to apply a tip credit against the full state minimum hourly wage only if the employer has informed its tipped employees in advance of the following requirements. These requirements include the amount of the cash wage that will be paid to the tipped employee, the amount of the tip credit which will be claimed by the employer, and this may not exceed the value of the tips actually received by the employee, that all tips received by the tipped employee must be retained by that employee, except in the case of a valid tip pool arrangement that's limited only to tipped employees. The tip credit shall not apply to any employee who has not been informed of these requirements in advance by their employer. When an employer takes a tip credit, overtime is calculated on the full minimum hourly wage and not the lower cash wage payment. And you can learn more about tipped workers at our website, which is listed here. Exceptions to the minimum wage. Part-time employees primarily engaged in the care and tending of children in the home of the employer, summer camps, conferences, and retreats operated by any nonprofit or religious corporation or association during June, July, August, and September, outside salespersons, and salespersons of motor vehicles. Record-keeping requirements. Employers must keep records that include the name of the employee, their address, the rate of pay, the gross and net wages, itemized deductions, the mode of payment, the check date or pay date, and earned sick leave. Employers must keep records. Employers need to keep daily and weekly records of the exact hours their employees work each day and within a week. Time records must be true and accurate to the work performed by an employee. For minors, employers must also document the arrival and departure times, in and out times for their meal periods, and the schedule of hours and breaks for minors must be posted. Wage payment law and paycheck deductions. An employer must notify employees of their rate of pay and their regular payday upon hiring. They must also notify them of any changes in rates of pay or paydays prior to those changes taking effect. They need to provide employees with a statement of deductions for each pay period, and also pay wages on regular pay days. Employers cannot withhold wages or make illegal deductions. Here is an example of a pay stub that an employee may receive once they get paid. And at the top, you'll see the earnings for the overtime, the straight time, and the paid time off, and how much they've been paid for overtime and their straight time, how many hours they've worked for each, and also the paid time off is good to include on the pay stub as well. So an employee understands how much time they've used, how much time is left over. This is especially good for tracking earned sick leave to be in compliance with that law. At the bottom, you see payroll deductions, and this is typically taxes that are taken out of an employee's paycheck. And in New Jersey, we want to make sure that all of the required taxes are listed on the payroll deductions on the pay stub, and that there's no illegal deductions, which could be breakages or shortages, or credit card fees being taken out of a tipped worker's paycheck. Just a few examples there. So it's really important to provide an employee with a statement of deductions on their paycheck every time they're being paid, whether it's in cash or any other method. Overtime requirements. Overtime pay for an hourly employee must be 1.5 times the employee's regular rate of pay for every hour that they work over 40 hours per week. Employers can require their employees to work overtime. However, in that case, then the employer must pay the appropriate overtime rate. The employer and the employee cannot together agree to violate the state overtime laws. So when the employee works more than 40 hours a week, starting with that 41st hour, they must be paid the proper overtime rate. Exemptions from the overtime law. There are two types of salaried employees, exempt and non-exempt. In order to be considered exempt from overtime, an employee must meet the individual criteria for the specific exemption claimed. Examples of this are the executive, professional, administrative, and outside sales, skilled mechanics, limousine drivers, certain trucking industry employees, labor on a farm engaged in agricultural work, computer professionals, etc. And all of these exemptions are defined in the federal Fair Labor Standards Act. So you have to make sure you're meeting the requirements for these specific exemptions if exempting an employee from overtime. And it should be noted that exemptions should be claimed and granted provided that they meet those requirements under the Federal Fair Labor Standards Act. Child labor. What does the Wage and Hour Division do? We do evaluations, investigations, and inspections. We review and approve employment certificates, and we provide education through child labor law presentations. It's important to note that minors under the age of 16 are not allowed to work more than 40 hours per week. They are not allowed to work overtime. Employers are required to register online with the New Jersey Department of Labor before hiring a minor. And you would go to this website, myworkingpapers.nj.gov, to get started. And this is the working papers for the minors. It's an online process now. It just started online on June 1st, 2023. Job opportunities for minors. At 11 years old, a minor can work in newspaper delivery. At 12 years old, they could work in agriculture. At 14 years old, they can work in general employment, but with some restrictions. At 16 years old, they can work in general employment, but with more hours and more choices. And theatrical work is available at any age for minors, provided that they have the correct working papers. Now we'll talk about job opportunities for youth at least 14 years old. This could include salespersons, including telemarketing, clerical and office jobs, hotel jobs, restaurant jobs, retail store jobs, supermarket and food store jobs, amusement industry jobs, hospital and health agency jobs, and science and research industry jobs. Work that minors can't do. An example of this would be cooking until the age of 16. However, if a 14 or 15-year-old wants to work at a fast food restaurant, they may cook only with electric or gas grills or automated deep fryers. Also, power tools, a minor would need to be 16 years old to work in that occupation. Factory work until age 16 as well. Deli slicers until age 18. Trash compactors until age 18. Any work on roofs, but a note on that is that minors working in an office at a construction site would have to be more than 30 feet away from the site. And minors who are 14 to 17 years old are permitted to work as volunteers for nonprofit organizations, an example of which would be Habitat for Humanity. And lifeguards until the age of 15, establishments serving alcohol until the age of 16, construction sites until age 18, any adult type entertainment until age 18, and poisonous acids, dyes, or chemicals until the age of 18. Hours of work for all minors. Minors may not work more than 6 consecutive days. They may not work for more than 6 continuous hours without an interval of at least 30 minutes for a meal period. And this is a new change. Previously it was 5 continuous hours, but the law has been updated. Now it is 6 continuous hours without a 30-minute meal period. And a meal period means that a minor is not constrained. They're allowed to leave the premises. An example of this would be a lifeguard that would be free to leave the pool and beach area when they're off duty. And 6 consecutive days does not need to be within one work week. For example, if a restaurant has a work week of Monday through Sunday, and the minor works Thursday, Friday, Saturday, and Sunday of week 1, then on week 2 she works Monday, Tuesday, and Wednesday. Within any given work week, she's only worked 3 to 4 days per week, but from Thursday to Wednesday she's worked 7 consecutive days, and this would be against the law. All meal periods for minors must be documented, and minors under 16 years of age may not be employed during school hours, but minors can work outside of school hours or during their school vacations. Hours of work for 14 and 15-year-olds. During the school weeks, they can work no more than 18 hours per week, no more than 3 hours per day on school days. They can work no more than 8 hours per day on Saturday or Sunday. They can work from 7 a.m. to 7 p.m. with limited exceptions. And this is new, the summer hours for 14 and 15-year-olds from the last day of school until Labor Day. They could work no more than 40 hours per week and no more than 8 hours per day. They can work from 7 a.m. to 9 p.m. in the summer, but they must have written parental permission to work after 7 p.m. in the summer. And the written parental permission to work after 7 p.m. only applies during that summer period. Hours of work for 16 or 17-year-olds. During school weeks, they can work no more than 40 hours per week, 8 hours per day. They can work from 6 a.m. to 11 p.m. on weekdays, and 6 a.m. to midnight on Fridays and Saturdays, or days not followed by a school day, with written parental permission. And another new change to the summer hours for 16 or 17-year-olds. From the last day of school until Labor Day, a minor between 16 and 18 years old may work up to 50 hours per week and up to 10 hours per day. They can work from 6 a.m. to 11 p.m. During vacation, they can work until midnight with written parental permission. And they can work until 3 a.m. in restaurant and seasonal amusements with written parental permission. Overtime for child labor, and this only applies in very limited circumstances. Overtime pay for an hourly employee must be 1.5 times the employee's regular rate of pay for every hour that they work over 40 hours per week. However, minors under 16 cannot in any circumstance work more than 40 hours per week. They're not eligible for overtime. Minors that are 16 or 17 years old are eligible for overtime in the following industries in which minors are entitled to minimum wage pay, and this would only apply during the summer period, where minors are able to work up to 50 hours per week during the period between the last day of school and Labor Day. And these industries where minors are entitled to overtime and the minimum wage include retail mercantile, food service, which is restaurants, hotel motel, beauty culture, laundry cleaning and dyeing, light manufacturing apparel, first processing of farm products. In any other job, those workers that are 16 or 17 years old can work up to 50 hours per week during the summer, but they would be exempt from overtime. It's only in these industries where the minor would be eligible for overtime pay if they work over 40 hours per week and they're 16 or 17 years old. Misclassification. Misclassification is the practice of not properly classifying a worker as an employee. This can take the form of identifying the worker as an independent contractor or simply not identifying the worker as either an employee or independent contractor by paying the worker off the books. What is misclassification? Misclassification is illegal and can occur when employers force their workers to form an LLC or sign an independent contractor agreement, or when employers issue a Form 1099 as opposed to a W-2 form. New Jersey uses what is called the ABC test to determine whether a worker is properly classified. Misclassification deprives workers of many rights that are guaranteed to employees. When an employee is paid cash off the books, that also means that the employer is not giving them access to the usual employment-based protections, such as access to Social Security insurance, unemployment insurance, temporary disability leave, and family insurances. Who is classified as an employee? And this is the ABC test. If a worker performs a service and is paid, they are presumed to be an employee, unless the employer can prove all three of the following requirements. A, that the individual has been and will continue to be free from the employer's control or direction. B, that the work is outside the usual course of business for which service is performed. And C, that the individual is engaged in an independently established trade, occupation, or profession, and the employer must prove all three of these following requirements for an employee to be classified as an independent contractor. These are some signs that an employee may be misclassified as an independent contractor. A few of these signs are that the employer directs and controls the worker's work, They provide training, tools, or supplies to do their job. They specify the worker's responsibilities. Or if the employee's work is similar or the same to the work that's done by the business where they're working, and also if that worker only works for one employer. These are just a few examples that may indicate that a worker is not truly independent to meet the independent contractor classification under the ABC test in New Jersey. Workers are protected against misclassification under New Jersey law. If a worker is misclassified, they are not in trouble, the employer is. Under New Jersey law, if an employee is misclassified, then they are entitled to the following remedies: back pay for payments that are due under New Jersey's wage and hour laws, entitlement to rights that are guaranteed to employees, which include workers' compensation, unemployment benefits, temporary disability insurance and family leave insurance, earned sick leave, and job-protected leave. Workers can be awarded up to 5% of their gross earnings over the past 12 months as a penalty for the illegal practice of misclassification, and they could also be eligible for reinstatement or correction of discriminatory actions taken in retaliation against an employee making an inquiry or complaint about possible misclassification. Employer obligations under the New Jersey Workers' Compensation Law. Employers are required to carry the appropriate workers' compensation insurance. If an employee is injured, they will receive benefits regardless of who is at fault. In exchange for these benefits, the employee cannot bring a civil action against their employer for pain and suffering or other damages, except in cases of intentional acts. Worker compensation insurance also provides death benefits to dependents of workers who have died as a result of their employment. Employers cannot discriminate against workers for claiming workers' compensation benefits, and you can learn more at our website, which is listed here. A wage and hour complaint. Employees can file a complaint in case of improper record keeping, failure to pay minimum wage and overtime, illegal deductions, failure to provide payment for earned sick leave, retaliation, threats or actual acts of retaliation, misclassification, child labor violations. These are just a few examples of possible violations of New Jersey's wage and hour laws that could lead to a complaint. What is retaliation? Retaliation occurs when an employer penalizes an employee for asserting certain workplace-related rights, such as the right to be paid the minimum wage or paid sick time. Retaliation can take many forms, including but not limited to getting fired, receiving a poor performance review, changed salary, increased oversight on job duties, changed workplace responsibilities, or being denied a raise or a promotion. Workers have a right to learn about their rights, to question how those rights are applied to them, to report violations of those rights, and to demand those rights without interference from their employer in asserting those rights. And workers can assert their rights by privately speaking with human resources about how they're being treated, sharing concerns about their workplace with a coworker, filing a complaint in court against an employer, and these above actions are protected activities under both state and federal law. New Jersey has very strong laws against retaliation, and workers are protected from being retaliated against if they have a wage and hour concern. Thank you for watching our presentation today, and if you have any further questions, you can reach out to the New Jersey Department of Labor and Workforce Development, Division of Wage and Hour Compliance, at our contact information that's listed here on this slide. We're happy to help answer any questions you might have, clarify any confusion or knowledge gaps with the laws, and we thank you for your interest in attending our webinar and your efforts to create good jobs and support workers in New Jersey.